Welcome back to Last Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss one of the most common ways that police officers obtain probable cause, which they then use to obtain a warrant and ultimately search your home. That is by snooping around and going through your trash. Now this might be a little bit familiar to you because I have previously discussed California versus Greenwood, a Supreme Court case that said that you do not have reasonable expectation of privacy in your trash that you leave on the curb for pickup. Now today we're going to look at a case which is a circuit case, and it goes through a variation of Greenwood. But instead, the defendant here says that he had a reasonable expectation of privacy because he invokes Florida versus Jardines, a Supreme Court case that said that you do have reasonable expectation of privacy when the officers make a physical intrusion into a constitutionally protected area of your home, known as curtilage. So today, we're going to look at this case, and we're going to see what you can do to protect yourself against officers going through your trash. And before we go on, I want to thank you for watching me on YouTube, hitting that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please consider giving it a 5-star review rating. And finally, if you want to support this channel, consider going to lostash.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks a lot for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we'll be discussing United States versus Jackson, and the facts of the case are pretty straightforward. Officers obtain information from a confidential informant that Dana Jackson is distributing narcotics out of his apartment. At 4 a.m. in the morning, 2 officers go to Jackson's apartment. They go through Jackson's trash by opening the bin, taking out 2 bags, and inside they find some incriminating evidence, including Ziploc bags that contain some drug residue. With this information, they have probable cause. They go to the magistrate, obtain a warrant to search Jackson's apartment. Inside, they find more drugs, firearms, and some cash. Mr. Jackson is indicted on a slew of drug and gun-related charges, but he says that his Fourth Amendment rights were violated when the officers searched his trash without a warrant. Now, before we go on and talk about the law and the Fourth Amendment, let's picture how these apartments look like. These were 2-story apartments facing each other, and in the back, each apartment had a 10 by 20 foot patio, which was enclosed and had a gate. Now, outside of these gates, there was 2-3 foot of grass, and in the middle, there was a sidewalk. This was an area that was commonly used by children to play and residences to gather and talk. Now, even though each building had a do not trespass sign on them, some of the residents later testified that the sidewalk was frequently used by individuals who didn't live in the area simply to walk through the apartments to go to wherever they were going. Now, the officers testified that when they opened up the trash bin, they didn't have to step a foot on Mr. Jackson's patio. That is because the trash bin was located on the grass and slightly on the sidewalk. So they said that because they didn't have a physical intrusion on Mr. Jackson's patio, this was covered by Greenwood, that the Fourth Amendment didn't apply. Now, Mr. Jackson's spouse said that usually she would leave the trash bin on the patio. And even though this time it was on the grass area, it was still not left there to be picked up by trash collectors. That is because she would still have to roll it down the sidewalk to the major street down the sidewalk for it to be picked up. So the question here, of course, does the Fourth Amendment protect Jackson against government intrusions when they search his trash bin? So let's take a look at the Fourth Amendment and see what it says. The Fourth Amendment, of course, provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The Supreme Court has recently emphasized that this text establishes simple baseline, namely when the government obtains information by physically intruding on persons, houses, papers, or effects, a search within the original meaning of the Fourth Amendment has undoubtedly occurred. That is, of course, your Supreme Court case Jardines. Applying this traditional property-based understanding of the Fourth Amendment, the Jardines court held that using a drug-sniffing dog on a homeowner's porch to investigate the contents of the home is a search within the meaning of the Fourth Amendment. The court explained that by going onto the home's front porch, the officers have undoubtedly entered the home's curtilage, that is the area immediately surrounding and associated with the home, that is treated as part of the home itself for the Fourth Amendment purposes. And because the officers' investigation took place in a constitutionally protected area, it was a search implicating the Fourth Amendment, unless the officers had license, either explicit or implicit, to gather information there. The court concluded that the officers lacked such permission because the background social norms that invite a visitor to the front door do not invite him there to conduct a search. The parties agree here that the patio was part of the curtilage of the apartment. There's no question there. The dispute lies in the area which is the grass strip plus the sidewalk. Is that part of the curtilage? In United States versus Dunn, the Supreme Court instructed that curtilage question should be resolved with particular reference to four factors. Number one, the proximity of the area claimed to be curtilage to the home. Number two, whether the area is included within the enclosure surrounding the home. Number three, the nature of the uses to which the area is put. And finally, number four, the steps taken by the resident to protect the area from observation by people passing by. First, with respect to proximity, we know that the area we're discussing is outside of the patio, about 20 feet away from the back door of the apartment. Now, 20 feet might not sound like it's that far, but the court says when we're dealing with apartments that are in close proximity to each other, 20 feet is significant. In terms of the second and fourth factor, we know that the area was outside of the patio, so it was not enclosed next to the house. But it is the third factor that's the most important. This was an area used by all the residents. It was the common area. And because of that, Mr. Jackson cannot prevail on the Jardines type of argument when he says that the officers physically intruded into his curtilage. The court concludes that this grass area and the sidewalk was not part of the curtilage. But we know that even though he can prevail on the property interest type of argument that was listed in the Jardines, we can still talk about the reasonable expectation of privacy. Does the owner of the home have a reasonable expectation of privacy in the trash? Well, we know from California versus Greenwood, a Supreme Court case, that the owner of the home does not have a reasonable expectation of privacy in the trash that is left outside for pickup. Now, of course, there are some differences between Greenwood and this case. In Greenwood, the trash was left outside for pickup, and in fact, the officers worked together with the trash collectors. They took out the trash, they didn't mix it with the other trash, and instead gave that bag to the police officers. They kind of worked as a team. Here, of course, the trash was left outside of the patio in the bin, but Jackson's spouse testified that she would still need to roll it down the sidewalk to the main street in order for it to be picked up. So the trash bin here was not left for pickup. Nevertheless, the court says this change is not that significant. That is because the trash bin was still left outside in public, where anybody, including children, vandals, animals, could get in and that includes also the police officers. They were also permitted to go into the trash because it was left outside of the curtilage of the home, in the common area. You do not have a reasonable expectation of privacy there. So, what do you need to take away from this case? Well, first of all, that this is a common technique. Officers often go through the trash in order to gather probable cause to obtain a warrant. So don't put anything incriminating into your trash. But if you do, consider another thing. Keep anything that you have an interest in close to the home. If you have an item inside the house, that will get the most protection because your home is specifically enumerated in the Fourth Amendment and gets the most protection. Of course, curtilage is also considered part of the home, and I have previously discussed curtilage many times. Go on my channel and search for curtilage videos, and you will see at least a dozen where I discuss what curtilage is and how it is treated by the court. Now, if you like this video and if you learned something, please like it. Please subscribe to my channel, share it with your friends and family. Consider taking this video and sharing it on Facebook, on some other social media. It really helps my channel, it grows, and it really makes me happy. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel and look like an absolute badass, buy a t-shirt that says "Do not arrest this person." People love it, and so will you. Thanks for watching.